Very good morning to everyone assembled here. Am I audible to everybody?
Yes. One of them is present through VC also.
Yes, sir.
Okay, excellent. At the very outset, I express my heartfelt gratitude to the Honorable the Chief Justice of the Sikkim High Court and the learned Director of the Judicial Academy for giving me this opportunity to address this esteemed group once again. The topic for today's deliberations is a Specific Relief Act. I start with a caveat. The caveat is that the Specific Relief Act as a topic for discussion in a forum like this is a little dry. And it might get, I hope it will not, but it might get a little tedious and theoretical. So please excuse me and please let me know if I need to move on faster than I'm moving or move on slower than I'm moving. I am essentially a commercial lawyer. So far as commercial lawyers and commercial courts are concerned, our holy book is the Civil Procedure Code, insofar as civil suits are concerned, and the Arbitration and Conciliation Act of 1996, so far as arbitral proceedings are concerned. But insofar as the substantive law is concerned, every commercial lawyer and every judge dealing with commercial litigation needs to deal with 4 basic laws: the Contract Act, the Sale of Goods Act, the Specific Relief Act, and the Transfer of Property Act. Today we deal with one of the 4 major statutes with which we need to deal with on a daily basis. When we talk of the Specific Relief Act, the genesis of the Specific Relief Act takes us back to British India. In fact, the genesis of all our laws take us back to British India, insofar as they are derived from the common law systems are concerned. In 1773, Frederick North was the then Prime Minister of Great Britain. He decided to introduce a codified system of governance of the possessions of the East India Company in India. So in 1773, the Regulating Act was enacted by the British Parliament. In the 1773 Regulating Act, amongst the plethora of changes and innovations which were brought about, was the establishment of 3 Supreme Courts. The first was the Supreme Court of Judicature at Fort William in Calcutta. That was in 1774. This was followed by the Supreme Court of Judicature in Madras in 1800 and the Supreme Court of Bombay in 1823. Why I mentioned the Regulating Act of 1773 and these 3 Supreme Courts is because Section 18 of the Regulating Act of 1773 gave power to the Supreme Courts to administer justice in accordance with the principles and practices being followed by the courts of chancery in England. And the courts of chancery in England administer justice in accordance with equity. Equity formed the basis of the specific reliefs that were granted by the Supreme Courts of Calcutta, Madras and Bombay. However, so far as the rest of British India is concerned, the principles and practices of the Chancery Courts were not applicable there. What was applicable there was custom and tradition. So in 1861, a law commission was constituted. The law commission laid down various principles and practices which should be enacted, one of which was codifying private law in Dominion India. This was in 1861, and therefore you all will find that in the 10-year period between 1872 and 1882, all our major laws were enacted within just this decade. So we have the Contract Act of 1872, we have the Evidence Act of 1872, we have the Specific Relief Act of 1877, we have the Negotiable Instruments Act of 1881, we have the Transfer of Property Act of 1882, we have the Trusts Act of 1882. A 10-year window in which all major laws which are still applicable today, so many years hence, were enacted by the British for doing in India, and they are applicable today in their pristine form. This 10 years was really the golden period of codification insofar as we are concerned. Of course, insofar as the Specific Relief Act is concerned, it was reenacted in 1963. But the reenactment of 1963 was nothing more than old wine in a new bottle. This is exactly what the government is doing today with the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. If you have a look at the Indian Evidence Act, which is now being retitled as the Bharatiya Sakshya Adhiniyam, which nobody can pronounce, and we will all call it as the BSA, which is going to be effective from the 1st of July, you can take it from me that there is nothing new in the Act except, one, the title of the Act has been changed from English to Hindi, God knows why. God knows and the makers know. But there is no real reason. Secondly is that reference to vakils and barristers have been changed to advocates, and such small ministerial changes have been made. And the one real change which has been made is making it codification as to how, so far as computerized documents, electronic records are concerned, how is that going to be made part of evidence? But this was also not required because we had Section 65B of the Indian Evidence Act, and certifications which were required under Section 65B, those provisions are again repeated. The only change, and it's a welcome change here, is that in the new BSA, they have given a form. All along, we lawyers and the judges were at sea as to whether the certification given was in accordance with the Evidence Act, whether it would suffice and whether it would be sufficient and in accordance with all the requirements of the statute. Now there is a statutory form. So really speaking, it's nothing more than old wine in a new bottle. And as you know, wine in a bottle does not ripen. Wine in casks, wooden casks, they ripen and they age, become better. Once in a bottle, it doesn't change. At best, it may ferment and become bad. And I have great apprehension that this is how the new laws will turn out to be. But please excuse me for saying this. Now, so far as the Specific Relief Act is concerned, this is what happened in 1963. But major amendments did take place. The major amendments took place in 2018, and they are of great importance because they've changed the entire concept of what we understood to be specific relief. One further change took place in 2019, and that is because of Article 370 being repealed, the Jammu and Kashmir Reorganization Act being enacted. Therefore, the statute was made applicable to state of Jammu and Kashmir also. But really speaking, after 1963, the real major changes are only in 2018. I'll come to the changes in 2018 because they actually encompass the entire law, and we'll have a look at the Specific Relief Act from the prism of the 2018 amendments. Now, so far as the Specific Relief Act is concerned, it is the law which grants specific reliefs in specific situations. But it is important to note that it is not an exhaustive enactment. it does not purport to lay down the entire law relating to grant of specific performance or declarations or injunctions. Therefore, the Specific Relief Act cannot, unlike the other statutes of the Contract Act, Sale of Goods Act, Transfer of Property Act, cannot be said to be a self-contained code. And it is not exhaustive of the entire law. I'll give you some examples to make why I say this. Now, so far as injunctions is concerned, injunctions are contained, as you all know, in sections 38 to 42 of the Specific Relief Act. 38, 39, 40, 41, 42 deal with a whole lot of injunctions and when injunctions ought to be granted and when not. But then there are special statutes which deal with injunctions also. And the Supreme Court says that when special statutes deal with injunctions, they are not to be whittled down by the provisions of the Specific Relief Act. Just by way of illustration, Section 135 of the Trademarks Act, Section 108 of the Patents Act, Section 55 of the Copyright Act, Sections 9 and 17 of the Arbitration Conciliation Act, they all give substantive rights to grant injunctions, whether in cases of infringement of intellectual property rights or in cases where injunction is necessary to maintain the status of the parties. Just likewise, Order 39 of the Civil Procedure Code also has provisions with regard to injunctions, which we apply them on a daily basis. The three considerations being prima facie case, balance of convenience and inconvenience, and irreparable injury. So the Supreme Court says the provisions of sections 38 and 39 are not exhaustive of the law relating to injunctions. They are to be taken together with the other laws which are in force, and if special statutes contain special provisions, they are to be given primacy. Also, so far as declaratory reliefs are concerned, I'll give you some more examples. Declarations are under section 34 of the Specific Relief Act. Now, this is again not exhaustive because there are provisions in the Transfer of Property Act with regard to relations between mortgagors and mortgagees where declarations can be given. There are provisions insofar as Partnership Act is concerned with regard to dissolution and accounts. Insofar as the grant of specific relief itself is concerned, I'll give you an example of a statute which comes into play regularly, which is the Consumer Protection Act. The Consumer Protection Act has special reliefs with regard to replacement of goods, removal of deficiencies in services, etc. These are not governed by the Specific Relief Act. They are governed by the special statute in the special situations in which they are applied. One more example, if I go on to the substantive provisions of the law, we all know that a contract of personal service cannot be specifically enforced. This is a well-established principle of law with which all of us are aware. If a contract of personal service is terminated, even if illegally, then the remedy is in damages and not reinstatement. But then reinstatement is granted by the industrial courts. Insofar as workmen are concerned, the labour courts and industrial tribunal have power under section 11 capital A of the Industrial Disputes Act of direct reinstatement. So mere awareness of the Specific Relief Act does not give a complete overview of the law relating to litigations that would come before the courts in respect of different subjects. It is absolutely imperative that one must have awareness of the specific subject in respect of which the grant of reliefs, whether by way of specific performance or injunctions or declarations or cancellations or rescissions, whatever the case may be. Now, with this background and having this perspective in mind, let us go into some of the major provisions of the Specific Relief Act. And the most important and major issue, which I think is there in the Specific Relief Act by virtue of the 2018 amendment, is that the discretionary power of courts has been whittled down, and grant of specific performance has been made mandatory the moment it satisfies statutory requirements. The second important aspect of the 2018 amendment is that a different class or a separate special class of litigations has been identified which relate to infrastructural work having public utility. This was not there anywhere before. This is a completely new concept which has been coming. A schedule has been brought into the Act. In the schedule, certain subject matters have been specified which relate to infrastructural contracts. And in infrastructural contracts, the statute now says no injunctions are to be granted. Why no injunctions are granted? Because that may impede the performance of projects having national importance. Secondly, suits are to be disposed of within a period of 12 months with a further maximum period of a 6-month extension. Now again, so far as this amendment is concerned, there are some ambiguities. The amendment, as is usually the case, does not take into account everything that could arrive by way of ambiguities, controversies, confusions. I'll give you 3 examples insofar as this infrastructural contract, this issue is concerned, when I deal with the topic in greater details, but just to have it in mind, we see infrastructure contracts, no injunctions to be granted. But unfortunately, while making this in the statute, the Parliament did not clarify whether the injunction which is not to be granted is an interim injunction by way of a temporary injunction, or is this the final injunction to be granted by way of permanent injunction in the suit. Secondly, when the statute says 12 months and thereafter only 6 months more, it does not say, does not clarify as to what is to be the result of the suit not being disposed of within the statutory time frame. So it provides a timeline but does not provide the default. In arbitration, the law says that an arbitrator must complete the arbitral proceedings within a maximum period of 1 year from the date of completion of pleadings. If it is not completed within 1 year, the parties can have it extended by consent for a maximum period of 6 months. But thereafter extension cannot be granted, it can only be granted by court. If extension is not granted, the default is provided in the statute. It says that the mandate of the arbitrator shall terminate. So if the consequence of the default is not provided, the law is that the direction no more remains mandatory, it becomes directory. If it's only a directory timeline, then really it loses its efficacy. The third aspect of the confusion that this leads to with regard to infrastructure contracts is, although the heading under which the provisions are provided insofar as infrastructure contracts, no injunction, list of infrastructure subjects is concerned, is provided in the sections. In the particular section where it says 12 months, it does not say whether it's restricted to only infrastructure contracts or not. So great ambiguity is there as to whether it relates to the entirety of the Specific Relief Act or only in relation to infrastructure contracts. And these 3 aspects have till date not been clarified by any judicial verdict, although from 2018 we are now in 2024. We'll have to await judgments in the Supreme Court unless there are statutory amendments. This is the second aspect. As I said, the first aspect is the doing away of judicial discretion in the grant of specific reliefs. Second is infrastructure contracts. The third important aspect of the amendments, according to me, is that there was a lot of confusion as to whether the provisions for recovery of possession of immovable property would apply to even agents of persons entitled to be in possession. Say for example, I am in lawful possession but I do not reside there. My caretaker resides and my caretaker has been dispossessed by a third party. There was a lot of confusion as to whether I could sue for recovery of possession or had it to be done by the caretaker or my agent or my servant who was in possession. Different high courts held differently. Now the law has been clarified. I, the owner, I am in juridical possession. In lawful possession, in possession is de jure mine, although de facto it may be in the possession of an agent, therefore I can sue. These are some of the important aspects of the 2018 amendment. With this perspective in mind, may I take a few important provisions of the Specific Relief Act. The first provision that I would like to take up is recovery of possession of immovable property. Now, this is Section 6 of the Specific Relief Act. Section 6 of the Specific Relief Act has major ramifications. Why? Because this gives relief to a person who has been dispossessed without the authority of law to get back possession by a summary proceeding. A summary proceeding from which no appeal lies, no revision lies. So this is substantive relief for a person who has been illegally dispossessed. You will find from the section which has been set out there, and if you have the bare axe with you, I can read along. There are essentially 7 requirements of this provision coming into play. The first possession is that the person must be dispossessed without his consent. That's the second provision. The third is otherwise then in due course of law. The fourth is notwithstanding any other title that may be set up. The fifth is that he must sue within 6 months of the date of dispossession. It does not apply against the government. And seventh is that no appeal shall lie. Now, importantly here, it is not relevant whether the person was in legal possession or not. He must be only illegally dispossessed. And in this suit, the question of title becomes irrelevant. In this suit, the plaintiff who seeks relief must take care to see whether the facts show that he was in possession and he was dispossessed without his consent, without the due process of law. Now let us take the case of I, the landowner, letting out the property to a tenant or a licensee. Now, the period of the tenancy or the period of the lease under the Transfer Property Act or the period of the lease or the period of the license has expired. I want to throw him out. Can I do so under this provision or not? The answer is no. I cannot do it because I was not dispossessed without my consent. The person entered into possession with my consent in accordance with law. So this provision will not apply. Now say in this suit where the license has expired or the lease has expired and now he is in illegal possession as a trespasser or as a tenant at sufferance, I file a suit under the regular Transfer of Property Act by terminating. And I get a decree of ejectment. In execution of the decree of ejectment, I threw out this person. In execution of the decree, by enforcing the decree in terms of Order 21, Rule 11, I throw him out. One day after he is thrown out, he illegally comes back into possession. Then I can apply this provision. Because he has now dispossessed me without my consent and without the due process of law or the due course of law. The restriction is that I must file the suit within 6 months. Then I get 3 advantages. 1, issue of title becomes irrelevant. 2, it's a summary proceeding where no other issue is relevant except the factum of dispossession. And thirdly, no appeal, no revision. Please have a look at subsection 3. Now what happens if I miss the bus, if I miss the 6 months period? Am I remedieless? No, one is not remedieless because the normal process of eviction in terms of the civil procedure code is still available. The process of eviction of a trespasser is still available under the Transfer of Property Act. But I lose the advantages which are attributable to this section. This is section 6 of the Transfer of the Specific Relief Act. One important aspect of section 6, which is not specifically mentioned, but has wide ramifications, at least so far as our country is concerned, is the question of adverse possession. There was a lot of controversy and dispute amongst the courts as to whether a person who says that he is in adverse possession can also exercise this right or not. Let us say I have entered into possession and I am in possession without having any title for 12 years. And the possession is open, it is continuous, it is uninterrupted, and it is hostile to the real owner. In other words, the real owner knows that I am in possession and yet does nothing for 12 years. The law says after 12 years, my title by adverse possession gets perfected, even against the real owner. Now there is a dispossession by force made by the real owner who actually had the title, or even maybe by a third party thief. Can I take advantage of section 6? There was a lot of dispute between different high courts, some of which said no, some of which said yes. Why did the high court say no? Because the concept which was understood of adverse possession is you can take adverse possession as a shield and not as a sword. You can use it as a defense but not as a ground for institution of suits. Now this proposition was held to be far-fetched and not correct. Several judgments, and the major judgment of the Supreme Court in this regard is Ravindra Kaur Grewal versus Manjeet Kaur. Ravindra Kaur Grewal versus Manjeet Kaur, which is reported in 2019, volume 8 Supreme Court cases, page 729. I'll just give the citation because that would be helpful. 2019, volume 8 Supreme Court cases, page 729. Here the Supreme Court said, would it not be inimical to all concepts of justice that the person in adverse possession has perfected his title, even against the lawful owner? Yet if he is dispossessed, he can't use this provision of section 6 and he has to fight the long, laborious, vexatious litigation under the Transfer of Property Act. So a person who is in adverse possession for more than 12 years, if he is forcefully dispossessed, either by the real owner or by a third party, has to keep quiet and not be able to take the advantages which the law provides him. This is not countenanced by section 6. So here in this judgment, the Supreme Court said the moment it stands established that title has been acquired by adverse possession, he must get every benefit of the title being vested in the person. The relevant portion of the judgment is quite relevant. I just placed the relevant portion from the Supreme Court judgment, which may be of some assistance. This is from the judgment of 2019, Volume 8, Supreme Court Cases 729. I just placed one paragraph which says exactly just what I said. We hold that a person in possession cannot be ousted by another person except by due procedure of law, and once 12 years period of adverse possession is over, even owner's right to eject him is lost, and the possessory owner acquires right, title and interest possessed by the outgoing person or the owner, as the case may be, against whom he has prescribed. In our opinion, consequence is that once the right, title or interest is acquired, it can be used as a sword by the plaintiff as well as a shield by the defendant within ken of Article 65 of the Act. 65 is a 12-year period. And any person who has perfected title by way of adverse possession can file suit for restoration of possession in case of dispossession. In case of dispossession by another person by taking law in his hands, a possessory suit can be maintained even before ripening of title by way of adverse possession. By perfection of title on extinguishment of owner's title, a person cannot be remedieless. In case he has been dispossessed by the owner after having lost the right by adverse possession, he can be evicted by the plaintiff by taking the plea of adverse possession. Similarly, any other person who might have been dispossessed, the plaintiff having perfected title by way of adverse possession can also evict until and unless such other person has perfected title against the plaintiff. So this aspect of section 6, that is, it is applicable even insofar as persons in adverse possession is concerned, is now well settled by the Supreme Court. 2019 Supreme Court has been followed right till recent times in 2020. The 2020 citation is 2020 Volume 3 Supreme Court Cases 220. 2020 Volume 3 Supreme Court Cases 2020 and 2020 Volume 10 Supreme Court Cases 264. 2020 Volume 10 Supreme Court Cases 264. Now, so if you have a look at section 6, one last aspect of section 6 before we move on. If a person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person, then the next portion is in red, I think, through whom he has been in possession or any person. This is the 2018 amendment. The rest of it was there before 2018. Through whom he has been in possession is the new introduction. And this introduction enables the rightful owner to sue even if his caretaker has been dispossessed or his tenant has been dispossessed. Because as I said, the juridical possession in law or de jure possession was with the owner always, and he continues to be in possession, although de facto physical possession may have been through a person who had been given possession by the owner. So this portion which was of some importance. The next provision, section 7, relates to recovery of specific movable property. In section 7, there is really nothing of great importance except that it gives the power to recover it in the manner provided by the Civil Procedure Code. But section 8 is of some importance. Section 8 gives power to the person who has lost possession of a movable property in certain situations to be having the right to compel the person who has taken possession to give it back specifically. Now, what are the situations? The first is if the thing claimed is held by the defendant as agent or trustee of the plaintiff. This is my watch. I give it to my colleague and ask him to keep it as my agent or my trustee. He cannot refuse to give it back to me. I am entitled to specifically ask him to deliver it back to me. Likewise, in a trust, the trustees have control over the property. But for whom is the property? For the beneficiary. If the trust deed provides that the beneficiary is to get the property in certain situations, and those situations have arisen, the trustee cannot hold it back. The trustee must deliver the property back. Then B, when compensation in money would not afford the plaintiff adequate relief for the loss of the thing claimed. Again, this is my watch. I have given it to Mr. X, or Mr. X has taken it. Now, I see this is a family heirloom. This has an antique value. I cannot get relief if you give me the money equivalent, because my family heirloom would be lost. I am then entitled to get specifically this watch back, because this is something whose compensation in money cannot afford me adequate relief. Let's take C, when it would be extremely difficult to ascertain the actual damage caused by its loss. Now let's take this very same watch. Somebody has taken it. I want it back. He says, I'll give you the money value. I say, this is a Rolex Prince, which is not available. How do I assess its value today? Sitting in India, I cannot assess the value of a Rolex Prince. Therefore, C will come into operation, whose value is difficult to ascertain. D, when possession of the thing claimed has been wrongfully transferred from the plaintiff. This is apparent on the face of it. When transfer itself, the taking away itself is illegal. Now, there are two assumptions here. The assumption is that compensation in money would not afford adequate relief, and it would be extremely difficult to ascertain the actual damage caused. These are in the explanations. So when these assumptions are there, then the onus to prove that compensation in money would afford adequate relief, or that it would not be difficult to ascertain the actual damage, would lie on the defendant. So the burden shifts at the very outset. Unlike in normal proceedings, when the onus is on the plaintiff to discharge at the outset, and only if the plaintiff discharges his onus, then the burden of proof shifts. Here the burden is on the defendant. So this is so far as section 8 is concerned. Then we come to the major portion where the 2018 amendment has completely changed the complexion of the law. That is section 10. This is how section 10 looked before the amendment. It was a substantially large section. If you all are looking at the new act, it will probably be at the footnote of the new act. Very interesting to note, please see how the new section 10 starts and just compare it side by side with how the old section 10 started. And that will give you the complete picture in itself. The new section 10 starts like this. Specific performance of a contract shall be enforced by the court subject to the provisions contained in section 11 to 14 and 16. So if 11 subsection 2, 14 and 16 are applicable, the court has no discretion but to grant specific performance. it cannot exercise a discretion to award only damages, saying that I will not award specific performance. This is just contrary to what was there earlier. Please have a look to see how section 10 started earlier. Except as otherwise provided in this chapter, the specific performance of any contract may in the discretion of the court be enforced. So even if everything was satisfied, even then discretion vested with the court to grant or not grant specific performance. And there lies the entire difference. The rest is only embellishments. I'll just give you an example. Let's say there is a contract with regard to sale of a property. I am the owner, I have agreed to sell a property to Mr. X. Now, today the property value was rupees 100. In breach of my contract, I have not sold it to him. He files a suit. 20 years later, when the time comes for trial, the value of the property, which was 100 rupees, has become 1 crore. Earlier, the court would have said that you will make unjust enrichment. I exercise my discretion to not give you specific performance, even though you may be deserving of it. I'll give you damages. I won't give you specific performance. Now the court has no discretion at all. If the requirements of section 11, 14 and 16 are satisfied, he has to give. The judicial officer has to give specific performance. Of course, when I use the expression he, it's in terms of the General Clauses Act, he means she. So please excuse me when it comes out like he, it means the judicial officer. No discretion is vested at all. Therein lies the difference. Now there are certain subtle but very important changes made in section 14, which again will have substantial ramification. Because if you've seen section 10 is relatable to section 11 subsection 2, section 14 and section 16. If conditions of 11 subsection 2, 14 and 16 are satisfied, specific performance has to be granted. 11 subsection 2 is not very important because it deals with trusts and breach of trust. So let's come directly to section 14. Now, insofar as section 14 is concerned, if you again keep it side by side with the earlier section 14, or if you have a look at the old section 14, then may I mark for you the portions which are no longer there. Now, if you see the old section 14, what subsection 1 says is, the following contracts cannot be specifically enforced. So these are the ones which could not be enforced. A contract for the non-performance of which compensation in money is an adequate relief. This has gone. This is no more there in the new section 14. So 14A as it stood earlier, 14.1A is gone, it's repealed. Now come to 14.1B of the old Act. A contract which runs into such minute or numerous details or which is so dependent on the personal qualifications or volition of the parties or otherwise from its nature is such that the court cannot enforce specific performance of its material terms. So there are three things here. Contract which runs into minute or numerous details, this is gone. This is no more there. Contract which is so dependent on the personal qualification, this remains. Let me give an example. There is a contract between the organizer of a music festival and a singer that she will come and perform. Can such a contract be performed? Specifically performed if the singer refuses to come. The contract depends upon the personal qualification of the singer. So it cannot be specifically performed. So all that you can claim is damages. This remains, but what goes is volition of the parties or otherwise from its nature. Now where has small b gone? Now b insofar as the old Act is concerned, the only thing which remains is contract which is dependent on personal qualifications. Where has it gone? It has become C. The new act, subsection C is dependent on personal qualifications of the parties. Now come to C of the old act, a contract which is in its nature determinable. This has become D of the new act. What is determinable? Most contracts are determinable. A contract by the employer or say a public sector undertaking giving contract to a contractor to make a road construction contract. Determinable. Construction of bridges, housing projects, these are determinable contracts. So C has become D and come to D of the old act, a contract the performance of which involves the performance of a continuous duty which the contract cannot supervise. That has become D. So what has now happened is that old section A is gone, old section B, only one part remains, that is dependent on personal qualifications. Old section C has become D, old section D has become B, and something new has now come in, which is the new A, which is not there at all in the old section. Now if you come back to the new section 14A, where a party to the contract has obtained substituted performance of a contract in accordance with the provisions of section 20. So if a party has obtained substituted performance, there is no question of having it specially performed again, because it has already been performed. What is substituted performance? I am a public sector undertaking. I have given a contract for construction of a road, widening and strengthening of a road, or for construction of a bridge. Now the contractor defaults. I terminate the contract and I give the contract to a third party to complete the balance, or I do it myself. This is the usual risk and cost the provision, and I recover the amount spent and the balance amount from the old contractor. This is substituted performance. The contract, to the extent that it has not been performed, is got performed either by me or by a third party at the cost and expenses of the old contractor. That is substituted performance. So the inclusion of this in 14A was logical. The important thing is the contract for the non-performance of which compensation in money is an adequate relief having gone. Most of the cases where judicial officers would refrain from granting specific relief related to old 14(1)A. This is now gone. Say for example, a particular contract where compensation can be quantified. Let us take my old example of agreeing of I being the owner of a property. I give it to a developer on the understanding that he will set up a building, and after the building has been constructed, there will be sharing of the saleable area between the owner and the developer, or there will be a sharing of the money which is recovered by selling the property. So at the very outset, both I, the owner, and the developer know as to what will be my profit margin, because it is calculable. Now in that contract, if there is a breach, the earlier law was that the non-performance compensation would be an adequate relief. So if it is terminated by the other, compensation would be good enough. But now that has gone. So if the developer wants specific performance of the agreement for development, although the compensation can be quantified and the compensation may be adequate, specific performance would still be granted. So the bar, the statutory bar of prohibition has now completely been extinguished. And this has its ramifications in later sections also. And I just indicate that while we are going ahead one by one. So this is section 14. Now if you turn to section 16, section 16 is again a section which is oft used. The section more or less remains the same, except this is again personal bars to relief. So it is substantially similar to section 14. Here also you will find that in A, the substituted performance part has been brought in rightly. B and C have remained substantially the same. B is somebody who is incapable of performing or who has violated the essential terms of the contract. If I am the person who is seeking specific performance of a contract and I have myself violated the contract, I cannot get specific performance. The person in breach cannot seek specific performance. So as the developer, in the old example that I was giving, if it was my obligation to get the plan sanctioned within a specific time frame, if it was my obligation to have the casting of the first floor roof done within a particular time frame, and I myself am in breach, then I cannot claim specific performance. That is B. Or if I have acted in fraud of the contract or willfully at variance with it or in subversion of the relationship intended to be established, these are all in line. In C is a very, very common issue which arises in n number of litigations, that is readiness and willingness. This readiness and willingness is a concept I am sure all of us are aware and something which we deal with on a regular basis. But there is a huge difference now by deleting one small word. If you see the old section 16, C, old 16C, who fails to aver and prove, and please see what it has now become, who fails to prove. Earlier, what would be the case of a negligent litigant with a plaint which has been poorly drafted is that if the averment was not there in the plaint, on that ground itself the suit would fail. Just because of improper or negligent drafting. Because it was conjunctive, aver and prove. So also if you see the explanation to section 16, for the purpose of clause C, then please see Roman 2. The plaintiff must aver. So having the pleading correct was imperative. It was all important. But now the legislature says, let's go to the root of the matter. Even if you have not pleaded it, have you been able to prove it? So if you've been able to prove it during trial, then it does not matter if you've not pleaded it. That is the result of a new amendment. Now, insofar as section 16 is concerned, readiness and willingness, however, is still mandatory. Earlier on, it was mandatory in the pleadings and in the proof, both by way of putting it in the plaint as well as establishing it during trial through the oral evidence and through documents. But now, mere proving it at the trial is good enough. Now, there are certain ramifications of readiness and willingness. It is not required to prove that I have the money and I have deposited it. It is enough to show that I had the ability to raise the money at any point of time. I need did not show the color or produce real money as the intending purchaser, claiming specific performance of a contract for sale. But I must show, and I must be able to show, that at all times I had the means to generate this money. Second aspect is this readiness and willingness, or this ability and the intent must be throughout and continuous from the time the contract was entered into till the time the decree is passed. And if the defendant can show that at any interim period or at any point of time he did not have the readiness or willingness, then the suit will fail. So it must be continuous, the readiness and willingness must be continuous from the time of the agreement right till the decree. Say for example, the usual example that I keep on giving with regard to development agreement. The developer is seeking specific performance because the owner is refusing to hand over. The developer says that I have done XYZ things, I am entitled to specific performance. But if it appears during the trial that there was a period of 6-8 months during which the developer stepped and did nothing, while the timeline showed that during this period certain steps had to be taken, the developer is unable to show that during that period of time he had the financial solvency to carry out development, which is why he did nothing, then readiness and willingness is not proved during the entire period. The judgment of the Supreme Court calls out an instance where at one point of time the developer was facing insolvency proceedings. Once this came to the fore, the Supreme Court says that during that period of time you did not have the financial solvency. So your readiness and willingness cannot be demonstrated during the entire period. So the case for specific performance must fail. The second aspect of readiness and willingness is that readiness and willingness must be proved by the person himself. A manager or a power of attorney holder would be unable to prove readiness and willingness. Therefore, in trial, evidence must be led by the person himself, or if it's a company, by principal officers of the company to show readiness and willingness. So this, as I said, was a second major aspect on which there has been substantial changes as a result of the 2018 amendment. Now the question arises is, so many changes, and I am yet to come to infrastructural projects which I have been mentioning, so many changes coming in the 1963 Act in 2018. From when are they to come into force? Because all over the country there are hundreds and thousands of civil litigations pending, which have already been instituted. Somewhere pleadings have been filed, somewhere trial is underway, somewhere trial has been conducted, completed, only judgment is awaited. Would these amendments apply retrospectively or prospectively? Here again there was a divergence of view. Until now, the Supreme Court has clarified. The judgment is a judgment of 3 honorable judges of the Supreme Court. The citation is 2023, Volume 1, Supreme Court Cases 355. 2023, Volume 1, Supreme Court Cases 355. The Supreme Court says that the law usually is that if the statute is procedural, no person has a right to procedure. So if the statute is procedural, it is usually taken that the amendment statute or the repealing statute would also be retrospective. But if the statute brings about substantive changes, then it must be prospective. because it affects legal rights of the parties which did not exist on the date of institution of the suit or even one day prior to the amendment coming in. Now the Supreme Court has a look at section 10, which we had a look at. The old section 10 and the new section 10. And the Supreme Court says, surely these changes are not mere procedure. These are substantive changes, making substantive changes to the rights of litigating parties. Therefore, they must be prospective in nature. Now, insofar as these 2018 amendments are concerned, the next major issue which I would like to deal with are the infrastructure projects. The infrastructure projects aspect is covered in amendments made to section 20. If I set it out here, it will be a bit cumbersome because the sections are large, but if you do have the barracks with you, it will be very easy to follow. Now, insofar as the infrastructure projects are concerned, I would first, before coming to the sections per se, request you to please come to the schedule, because that will give you an idea of what the legislature wanted to cover. There is a schedule which has been incorporated by the 2018 amendment. Which says category of projects and infrastructure subsectors. And the categories are transport, energy, water and sanitation, communication, social and commercial infrastructure, and subheads are there with regard to the infrastructural subsectors. Now these have been culled out by the Department of Economic Affairs of the Government of India, which is the nodal agency for specifying the categories of projects and infrastructure subsectors. Now, insofar as these projects are concerned, projects relatable to roads and bridges, say for example roads and bridges, ports, shipyards, inland waterways, airports, etc., one can understand that if an injunction is granted, whether by the High Court or by the principal civil court of original jurisdiction or the lowest court of the state, it might hamper projects of national importance which have great public utility. So there the legislature says, whatever be the cause, even if it is justified, injunctions are not to be granted. And the legislature sets up special courts to try the special category of suits. Now if you come back to section 20, capital A, subsection 1, no injunction shall be granted by a court in a suit under this act involving a contract relating to an infrastructure project specified in the schedule, where granting injunction would cause impediment or delay in the progress or completion of such infrastructure project. The purpose is also encapsulated here, that an injunction would cause impediment or delay. No injunction is to be granted. Now it is unclear whether the injunction is to be temporary injunction or a permanent injunction. Now please come to the explanation. For the purposes of this section, section 20D and clause HA of section 41, the expression infrastructure project means categories of projects and infrastructure subsectors mentioned in the schedule. So that's how the schedule comes in. So it is in respect of the scheduled projects that no injunction is to be granted. So it is as if the judicial officer as a post office would refuse injunction, even if it finds merit in the case. What would be the remedy of the litigant? Say for example, my land over which I have a right, a national highway is being constructed without acquiring the property in accordance with the Acquisition Act. Even then, the statute now says no injunction would be granted. It appears to be anomalous to the concept of where there's a right, there is a remedy. But then that person would have a right under the Acquisition Act or by way of damages. But no injunction can be granted in terms of 20 capital A. Now please have a look at subsection 2. The central government may, depending upon the requirement for development of infrastructure projects, and if it considers necessary or expedient to do so, by notification in the official gazette, amend the schedule relating to any category of projects or infrastructure subsectors. So it is up to the central government to increase or decrease the number of projects which are specified. 3 is also in line with that, saying notifications are to be placed in each House of Parliament for a total period of 30 days only. And if within 30 days in the Parliament or any of the houses ask for a notification or say that the notification should not be made, well enough. But if it is not touched in the 30 days, it goes ahead. 20B talks of special courts. Now please have a look at 20B. The state government, in consultation with the Chief Justice of the High Court, shall designate by notification published in the official gazette one or more civil courts as special courts within the local limits of the area to exercise jurisdiction and try a suit under this Act in respect of contracts relating to infrastructure projects. So the injunction which is not to be granted under 20 capital A1, in my view, must relate to temporary injunctions, because you are in any case constituting a special court to try a suit for declaration and injunction and compensation, where mandatory perpetual injunction may or may not lie. Otherwise, what would be the purpose of constituting a special court? If the court is to keep a hands-off policy and not to touch the project, the suit becomes infructuous, and all that would remain would be a monetary decree. So there is a great ambiguity here which is required to be clarified by the legislature as to whether the injunction in 20 capital A1 is only temporary injunction, which is contained in section 38, or does it relate even to mandatory to perpetual injunctions in 38? Because the considerations for grant of perpetual injunction in 38 and temporary injunctions are different. Temporary injunctions will be governed by, as I said, special statutes or by Order 39 of the Civil Procedure Code, where all that you see is a prima facie case, balance of convenience, and irreparable injury. So there is a great ambiguity here which requires to be clarified. Then please have a look at 20C. Notwithstanding anything contained in the Code of Civil Procedure, a suit filed under the provisions of this Act shall be disposed of by the court within a period of 12 months from the date of service of summons to the defendant, provided that the said period may be extended for a further period not exceeding 6 months in aggregate, after recording reasons in writing for such extension by the court. All very well, but if not, then what? the legislature is silent. There has to be some clarification giving some indication as to what would be the fate of a suit which is not disposed of within a year and a half. Most civil courts have such a backlog that it is humanly impossible to dispose of proceedings within this sort of a timeline. Now, so far as Section 20C is concerned, so long as the amendment, so long as there is no clarification, it must therefore mean that the provision giving the timeline is directory. It must mean so. Now, what would be a project where there is public interest involved? And what should be the reaction of the court? There are not too many judgments as yet on the issue. But the Supreme Court has gone into the issue of infrastructure projects in relation to tenders. And that is a judgment where the concept of fair play or liberty to the employer to interpret its documents as it thinks fit, less interference by the courts in matters relating to tenders or where expert views are required, and the contours of Section 20A, B and C have been considered. This is the judgment of NG Projects, N for Nagpur, G for Gangtok, NG Projects Limited versus Vinod Kumar Jain. And this is reported in 2022, Volume 6, Supreme Court Cases 127. 2022, Volume 6, Supreme Court Cases, page 127. What happened here in this judgment of NG Projects is very interesting. The Road Construction Department of Jharkhand, they invited tenders for construction of a particular road. Now, the respondent participated in the tender, submitted the bank guarantee as bid security, but the tender was cancelled. Then a fresh tendering process took place. The respondent as well as the petitioner, who was the successful tenderer, both submitted tenders. Now, insofar as the bank guarantee or the bank guarantee, the secure deposit bank guarantee is concerned, the respondent number one, having already deposited the bank guarantee in the earlier tender, said, I am forwarding this bank guarantee insofar as this tender also is concerned, and gave a forwarding letter saying that please consider this bank guarantee which was given earlier in terms of the earlier tender to be a bank guarantee under the new tender also. This bank guarantee format was found to be defective because it was in terms of the earlier tender, and the amount was also found to be slightly different. But the person to whom the tender was awarded suffered from the same deficiency. But the Road Construction Department gave the tender to the successful tenderer, disregarding the objections of the unsuccessful tenderer who had participated and was otherwise technically qualified. The High Court held that no, the tender process has been vitiated because you have not created a level playing field. All tenderers must be equally taken into account, and if the successful tenderer's bid suffers from the same fallacies, same infirmities, then he cannot be awarded. That would be violation of Article 14 of the Constitution. When the matter went to the Supreme Court went into the concept of these infrastructure projects under Section 20, 20A, 20B and 20C. And the Supreme Court held that having regard to the fact that these overriding provisions have now come in, and construction of road being an infrastructure project which is governed by the schedule the High Court should have stayed its hands off from this sort of a matter. It uses such deprecating words. I'll just read this portion. Since the construction of road is an infrastructure project, and keeping in view the intent of the legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. So the High Court is being said that you ought not to have entered into the arena of disputes insofar as the infrastructure projects is concerned. It's now governed by 28, 20B and 20C, where no injunction is to be granted. So this keep your hands off policy sometimes works. It works when you consider a national good is concerned, because any stay would mean fresh deadlines, fresh tendering process may have to be done, increase in costs, escalation and sufferance of public good, because for that period the public would not be able to get the civic services to be provided by the infrastructure. And this is in line with the concept that when there is overwhelming public policy involved and public good involved, then individual good or individual interest cannot override public interest. But then what of the poor individual who has suffered? For them, the Supreme Court in this judgment says, you file a civil suit for damages. The portion where the Supreme Court says you file a civil suit is in reference to an earlier judgment, and I'll place that relevant portion. It says a contract, this is from this judgment of NG Projects itself. It says a contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, courts will not, in exercise of power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest, or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride and business rivalry to make mountains out of molehills of some technical or procedural violation or some prejudice to self, and persuade courts to interfere by exercising power of judicial review should be resisted. Such interferences, either interim or final, may hold up public works for years or delay relief and succor to thousands and millions, and may increase the project cost manifold. Therefore, court, before interfering in tender or contractual matters in exercise of power of judicial review, should pose to itself the following questions. 1. Whether the process adopted or decision made by the authority is mala fide or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached, and 2. Whether public interest is affected. If the answers are in the negative, there should be no interference. And you will hardly find a case where decision is mala fide. Mala fide means malice, not only malice in fact but malice in law. Intended to favor someone. Impossible to prove. And thirdly, whether the process is such that it's so arbitrary and irrational that the court would say this is perverse. No reasonable authority acting reasonably can take such a decision, and public interest being affected. So these are situations now which have now come to the fore by virtue of the 2018 amendment, and they've affected in large scale the perception of the courts when they deal with applications and suits for declarations and injunctions insofar as these infrastructure projects are concerned. With this, can we take a break for 5 minutes? Should we start? So we are done with section 20, the infrastructure projects portion that I wanted to talk to you about. The next portion, where the 2018 amendment has had its effect, is on section 21. While very small but very significant incorporation of just a couple of words. In fact, exactly 3 words have been added, and it makes a substantial change to section 21, which deals with compensation. Now, if you would please compare section 21 subsection 1 with what it stood before amendment, you would find the earlier provision in the footnote. 21 subsection 1, in a suit for a specific performance of a contract, the plaintiff may also claim compensation for its breach in addition to such performance. Now let's ignore what was there earlier. On the reading of this provision, on a plain literal reading, what does it mean? The plaintiff may also claim compensation in addition to specific performance. So a plaintiff is not restricted to claiming only damages or only specific performance, it can claim both. So if I have a case, I go back to my oft-quoted illustration of a developer. The landlord or the owner is delaying in handing over physical possession of the property which is to be developed. The developer files a suit for specific performance, saying that you hand me the property. In addition to that, he can also claim damages. Damages for the delay, loss of profit, whatever. Now please see what was there earlier. In addition to was earlier either in addition to or in substitution of. So the change now is that one need not ignore or one need not give up the prayer for specific performance in order to claim damages. And that is of some importance. Now, insofar as damages are concerned, one important aspect that I would like to highlight, again relatable to negligible drafting of pleadings, is in section 21 subsection 5, because the rest is something which all of you will have looked at and taken care of, but 21 subsection 5 is important. No compensation shall be awarded under this section unless the plaintiff has claimed such compensation in his plaint. I'll give you an example of a judgment of the Supreme Court. A company called Universal Petrochemicals. It filed a suit for specific performance of a collaboration agreement that it had with a German company. Under this collaboration agreement, Universal Petrochemicals had the right to do distribution, branding, blending, marketing of lubricants. Now this German company was taken over by a UK entity. This UK entity terminated the collaboration agreement unfairly. Now the termination was challenged in court. Now the termination being challenged, the High Court held that no, we cannot grant you specific performance, although you have claimed it, because of the bar contained in section 14. Please come back to section 14 once. Because of the bar contained in section 14 1B, B for Bombay. Because a contract relating to distribution, blending, branding, marketing requires continuous supervision, which the court cannot supervise. Such a contract is difficult for the court to supervise. Therefore, specific performance we cannot grant you. We are granting an injunction restraining any other third party from being given this contract, this particular contract, but we cannot grant you specific performance. So then the matter went to the Supreme Court, and in the Supreme Court, the Universal Petrochemical said that very well, then kindly give us damages. Then it transpired that there was no pleading claiming damages. The relief was not claimed. Question arose, cannot damages be permitted in equity? The law is equity follows the law, and not that law follows equity. And the Supreme Court held that if there is a specific provision in a statute which expressly bars or prohibits grant of relief in a particular situation, one cannot override that. The Specific Relief Act expressly in subsection 5 of section 21 says that you cannot get compensation unless you ask for it. The Supreme Court said that had an amendment application been made and the plaintiff had been amended at any stage of the proceedings, it could have been granted. But now it cannot be granted. So section 21 subsection 5 had its ramifications. The judgment that I was referring to, where the concept of section 21, 14(1)(b), non-grant of compensation if no remedies, no relief is claimed, that is reported in 2022, volume 6 Supreme Court cases, page 157. 2022, volume 6 Supreme Court cases, 157. The other issue is the two acts coming into play at a time. 21 says compensation can be awarded. How is one to quantify compensation? Because the judicial officer or civil court, while can say very well, we find that there is a breach by the defendant, the party is entitled to specific performance, party is also entitled to compensation. Now, how is one to quantify compensation? For that, one would need to look to the Contract Act and section 73 of the Contract Act, which provides the manner of quantification of damages. If you have a look at subsection 4 of section 21, you will find that there is express provision made to apply section 73 of the Contract Act. If you have a look at section 21 subsection 4, what it says is that in determining the amount of any compensation awarded under this section, the court shall be guided by the principles specified in section 73 of the Indian Contract Act. Section 73 requires proof to be given of the damages suffered. One must be able to prove that I have suffered damages. While dealing with section 73, courts have held that it is possible that one may not be able to quantify damages with mathematical precision or with exactitude, but you must be able to prove whatever damages you have suffered broadly. A broad evaluation will suffice. Even certain amount of guesswork will suffice, but that does not dispense with the requirement of proof. It is imperative that there must be legal damages. Let's say, for example, there's a contract for getting certain work done. Now the contractor defaults and commits a breach. I terminate the contract, and in exercise of my powers under substituted performance, which I had referred before the break, I appoint a third party to get the work done. Now the third party claims a sum lesser than the amount that I would have had to pay the earlier person. Then I have not suffered any damages. No legal damages have been suffered. So the mere fact that there was breach does not ipso facto mean that it will result in damages. There is no direct correlation saying irrespective of actual damages and proof, breach, therefore damages. No. Breach must lead to legal damages, then comes the question of quantification. So in these risk cost tenders, or what we say as risk purchase tenders, which is really a fallout of the provision of substituted performance under section 20, when the government, let's say it gets a road being constructed or a dam being constructed, any other infrastructure project, it engages somebody. The contractor commits breach. The contract is terminated. The contract itself usually says that the employer has the right to enter into the site, to remove the earlier contractor and get the work done at his risk and cost. At his risk and cost means whatever is the amount that the new tenderer claims for the balance work to be done, that will be recovered from the earlier contractor. That is recompense or recovery on actuals. But damages by way of compensation is only if the new contractor charges more than what would have been the amount payable to the earlier contractor. So in terms of section 21 subsection 4, whenever compensation is to be determined, it is in relation to section 73. That means the court must then go into the issue of whether legal damages have been suffered. And as I said, mathematical precision is not possible, exactitude is not required, but broadly one must be able to assess damages. Let's say, for example, there's a contract where there's an illegal termination by the government. The contractor who was awarded this contract to construct the road, he claims damages by way of loss of profit for not being able to complete the work. Now it is held that the contract was wrongfully terminated. It ought not to have been terminated. So the contractor says that had I completed the work, I would have earned profit. Because it was wrongfully terminated and I could not complete the work, I have suffered loss of my profit margin. Now how does one assess loss of profit? Because it is intangible. There cannot be any exactitude in that. In every bill that a government pays to a contractor, in any construction contract or in any building contract, there are certain variables in the bill. One is the cost of the equipment, the cost of acquisition of the equipment, whether it is by hire purchase or by actual purchase. Second is the cost of raw materials for the construction. Third is the cost of labor. And the fourth is the profit margin. What is the profit margin is a variable which cannot be quantified. Supreme Court steps in and says, we understand that profit margin cannot be quantified. But every conscientious government employer would naturally in the cost factor in some profit margin for the contractor. And what is that profit margin? It may be there in the codes. For example, the CPWD works manual may have it, or the MOT, Ministry of Roads, their manuals would have it. Or if it is not there anywhere, the profit margin that the contractor would earn, then you apply 10 to 15% of the value of the work as the profit margin. So there, by judicial views which have been strengthened over a catena of judgments, one gets an idea as to how one is to assess loss of profit. The other way to assess loss of profit is to get a chartered accountant, to get the balance sheet and the profit and loss accounts, make an assessment of what was the profit margin of the company over the past couple of years, and then to make an assessment. Now all these methods are subjective. You cannot ever arrive at an exact figure as what would be a profit margin in this contract. Therefore, mathematical exactitude is not possible. But then you must have some broad overview or method by which you say that this is what I could have earned or would have earned in terms of section 73. So this is insofar as section 21 is concerned, and so far as the other provisions of section 21 is concerned, it is essentially that now there is no bar to claiming compensation even if we are claiming specific performance. Now we come to an important chapter which is with regard to cancellation of contracts. Cancellation and rescission are usually expressions that we use interchangeably, but they are not. You would find that rescission of contracts are dealt with in section 27 and 28, whereas cancellations are in section 31. Now please see, I will just indicate the broad distinctions, because as it would appear on a normal reading, a literal reading, they appear to be more or less the same things. One is asking for a contract to be rescinded. On the other hand, one is asking for something to be cancelled. What are the differences? It would appear on the face of the section itself, and that would possibly be the easiest way to understand this. Section 27, it relates to contracts. Please see, section 27 subsection 1 starts by saying any person interested in a contract may sue to have it rescinded. Now please turn to section 31. Any person against whom a written instrument is void or voidable. So it need not relate to a contract. It can be any written instrument. It can even be a notice, a demand. It need not be a contract between the parties. Any instrument can be cancelled, whereas rescission is related to contracts. Now please see, so far as rescission is concerned, section 27, what does it say? It says that the court you may sue to have it rescinded, and such rescission may be adjudged by the court in XYZ situations. And now please compare with section 31. What are you asking for? You are asking for the document to be adjudged void or voidable. So you are asking for an adjudication that this document, if it continues to exist, may cause me injury. Please have it declared to be void or voidable. Whereas insofar as rescission is concerned under section 27, you are not asking for it to be adjudged void or voidable, but you are asking it to be rescinded because it is voidable. There is a subtle difference, please note that. The next change, please see that if the written instrument is, say for example, a deed which has been registered, the cancellation would be complete when, if you please see section 31 subsection 1, the last two lines. Court may in its discretion so adjudge it and order it to be delivered up and cancelled. This concept of delivery up of the document and is not there in rescission. And then if you continue with 31 subsection 2, if the instrument has been registered under the Indian Registration Act, The court shall also send a copy of its decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his books the fact of its cancellation. So the important factor is if a particular instrument is cancelled by the court. Let's say a conveyance between two parties is cancelled, or any other agreement is cancelled, a development agreement is cancelled, a registered development agreement is cancelled. How would third parties or persons who are carrying out title searches or other searches for their litigation purposes or for their documentation purposes be able to know that this particular document has actually been cancelled? Therefore, the duty is on the judicial officer. The moment the judicial officer directs that this document instrument is cancelled, to send a copy to the registrar's office so that it is noted in the registrar's book against that particular document that this document has stood cancelled. The subsection 2 of section 31 requires, it is imperative that the judicial officer should send the copy of its decree to the officer in whose office the instrument has been so registered. That's the registering authority. And such officer, that is the registering officer, shall note on the copy of the instrument contained in his books the fact of its cancellation. So then it is available to the world at large that this instrument has stood cancelled and is no longer valid and binding between the parties. Now, a very important question arises insofar as cancellation is concerned. Let us say I enter into an agreement with Mr. X, under which I am to purchase Mr. X's property. I am going to buy from Mr. X, Mr. X is to sell to me. Now Mr. X, instead of selling to me, enters into an agreement with Mr. Y in respect of the same property. Now I have filed a suit for specific performance of my agreement for sale. The question which arises is, once I come to know that there is an agreement with Mr. X and the third party, Mr. Y, do I need cancellation of the agreement between X and Y? And if I don't ask for that relief, what will happen to my suit? Does it become a non-starter? There the Supreme Court has clarified and said it is not required. All that you need to do as a plaintiff is to make the third party, Mr. Y, a party to your suit and seek the relief of specific performance against the original owner and ask for a direction that the subsequent transferee should be made a party to the conveyance or the execution of the deed, so that the title can be properly transferred. You don't need to separately have that agreement cancelled because you are not a party to that document. You ask for specific performance of your document, making that third party a party in your document, so that the title is properly transferred, and that is enough. Now, so far as this judgment is concerned, which laid down after a lot of judgments of different courts giving different views, this is 2022, recent judgment of 2022, Volume 7, Supreme Court Cases 384. 2022, Volume 7, Supreme Court Cases 384. Volume 7, Supreme Court Cases 384. It is not necessary to seek cancellation of the deed executed between the vendor and the subsequent purchaser. All that is required is that you implead the subsequent purchaser in the suit, seek relief of specific performance against the original owner, and seek a direction to the subsequent purchaser to join in the execution of the deed, so that the title is completely conveyed. So this is so far as cancellation of documents is concerned. Then we come to declaratory decrees. Declaratory decrees is a major chapter. There is a portion in this schedule which was given to me. I'm sure you have this schedule. I thought one line of this schedule was a trick question. Because initially when I read it, I really thought it was a trick question. If you come to the second part, session 2, B, declaratory reliefs, scope and ambit, etc., the last sentence. Can court declare civil death of a person? In my complete ignorance, I thought that I was being made to go up the garden path. But when I checked up the law, it's very interesting. There is scope for courts to grant declaration of civil death. And I'll come to this aspect when I'm dealing with declaratory decrees. Now if you come to section 34, this deals with declaratory decrees. Two aspects very important in section 34. One is who can ask for a declaratory decree. Any person entitled to a legal character or to any right as to any property. Legal character means legal status or legal right to any property. Such a person can institute. And what must be there? There must be a person who is denying or is interested to deny the plaintiff's title to such character or right. So the existence of both are a sine qua non. One is I am entitled to a legal character or a right to a property, and there is a person who is denying or is interested to deny my title to such character. Then the court will grant declaratory decrees. But there is a caveat that if I am entitled to a declaration as well as a consequential relief, and I don't ask for the consequential relief, then the court will not give me the declaration. Please see the proviso. So this is by way of abundant precaution, again something lawyers have to be very careful when they are drafting their claims, and judicial officers will be careful to see how the plaint has been made out. What is the case made out? Please see the proviso, provided that no court shall make any such declaration where the plaintiff being entitled to seek relief, then a mere declaration of title omits to do so. Suppose I am entitled to a declaration that this property is mine, I am the sole and absolute owner of the property, but I don't ask for an injunction restraining the person who is trying to trespass, then the court will also not give me the declaration. Because although I am entitled to ask for consequential reliefs, I omitted to do so. So when I seek declaration of title, I must also take care to ask for all consequential reliefs which are concomitant to the declaration. This is of great importance. Now the question arises is, suppose a civil suit has been filed, where the plaintiff has sought a relief of declaration, but has forgotten to ask for injunction. Can that suit be dismissed or rejected under Order 7, Rule 11 on the ground of being barred by law? Order 7, Rule 11, claim can be rejected on several grounds, A, B, C, D, E. Claim does not have a cause of action, it does not demonstrate a cause of action, etc. Barred by law is D. Their usual tendency was that, see the prayer, declaration is asked for, consequential relief is not asked for, declaration would fail. Therefore, the suit is liable to be rejected. But change in view took place very recently in 2022, where the Supreme Court said that, see, the question of whether the declaration would be made or not made is something which would arise only at the time of passing of the decree, not today. Today the suit is not fatal. if ultimately at the trial we find that the plaintiff would succeed and he would be entitled to the declaration, then we can't grant that declaration because no consequential relief has been paid. That does not bar the suit from now proceeding. Suit may be dismissed ultimately on merits. Or it may be that the plaintiff has other prayers, including prayers for compensation, which can be granted. So merely because the proviso has not been followed does not mean that today under Order 7 Rule 11 the suit would stand dismissed. This judgment is recent judgment of 2022. The citation is 2022 volume 8 Supreme Court cases 633. 2022 volume 8 Supreme Court cases 633. It's Frost International Limited versus Milan Developers. Frost International Limited versus Milan Developers. And it deals with the question of rejection of plaint under Order 7 Rule 11 of the Civil Procedure Code and says that the question as to whether the impediment of the proviso to section 34 is a bar to the suit or not, that would have to be considered at the time of final adjudication of the suit. As a question of granting further relief or consequential relief arises only if the court grants the declaration. If the plaintiff is unsuccessful in seeking the main relief of declaration, then the question of granting any consequential relief would not arise at all. Therefore, the omission on the part of the plaintiff to claim now consequential relief is irrelevant. It becomes relevant only post-trial. So, Order 7 Rule 11 would not apply. Maybe ultimately the suit may fail, but the rejection of the claim can't be given now. Another important issue is what happens to declarations which overlap with reliefs that the defendant could have sought. Let's say, for example, I give a check to Mr. X. The check bounces, it's dishonored. I have a right under section 138 of the Negotiable Instruments Act to initiate proceedings. Can Mr. X file a suit saying that this check ought not to be considered as a ground for instituting proceedings because the check was only given as a security check and was not meant to be encashed at all? There the Supreme Court says no, you can't ask for such a declaration and you can't even get an injunction in this regard. You can't ask for a declaration because A, it is in violation of the Negotiable Instruments Act, section 118A, and you can't get an injunction also because it is in violation of section 41 of the Specific Relief Act. So let me come to section 41 of the Specific Relief Act. Section 41 is a very wide and comprehensive provision, and it is sometimes overlooked when courts give injunctions. Temporary injunctions under Order 39 of the Civil Procedure Code. We sometimes overlook section 41, but section 41 has to be kept in mind at all material times. Let's take section 41 at depth. 41 injunction when refused. An injunction cannot be granted. First, let's come to my case, 41D. Injunction cannot be granted to restrain any person from instituting or prosecuting any proceeding in a criminal matter. So the net effect of the person to whom I gave the check, person who gave me the check, the net effect of that gentleman filing a suit and asking for an injunction that this check should be treated as a security check and not a check in payment of indebtedness or liability, and therefore injunct him from enforcing the check would be in violation of D. Now, I just have a look at one or two other subsections in random before we take it in seriatim. Please have a look at E. Injunction cannot be granted to prevent the breach of a contract the performance of which would not be specifically enforced. Which are contracts which cannot be specifically enforced now? Section 14 and Section 16. Right? So please have a look at Section 14 and 16 once more. Section 14, contracts not specifically enforceable. A, where a party to the contract has obtained substituted performance. That means I've got the work done by somebody else or myself, but I've got the work done. So substituted performance. B, a contract the performance of which involves the performance of a continuous duty which the court cannot supervise. C, a contract which is so dependent on the personal qualifications of the parties. And D, a contract which is in its nature determinable. So if a suit is filed in respect of a contract which falls within A, B, C or D, such a contract cannot be specifically enforced because it is barred by Section 14. And because it cannot be specifically enforced, the court cannot grant an injunction in terms of 41E. So when an injunction is asked from a court, the court will see whether this contract, I could have enforced it. If I can't enforce it, I cannot give an injunction. What is the principle? The principle is that injunction is granted in aid of the final relief. Any interlocutory relief is granted in aid of the final relief in the suit. What is the final relief? The final relief is the relief of specific performance of the contract. If specific relief of the contract cannot be granted because of the legal prohibition contained in Section 14, then the interim relief of injunction cannot also be granted. So that is the philosophy behind the section. The Section 14 subsection E makes it clear that if the court cannot grant specific performance, it cannot also grant injunction in such an act. Even if prima facie case is made out, balance of convenience is made out, irreparable injury is made out. Even then you can't grant it. Now the other is Section 16. Please come back to Section 16. Suppose it is a contract where a person has obtained substituted service, or the person, that is the plaintiff, has become incapable of performing, or has himself violated essential terms of the contract, or has acted in fraud of the contract, or has willfully acted in variance with or in subversion of the relationship intended to be established by the contract, or has failed to prove that he has been ready and willing to perform, then also one cannot give specific performance, therefore one can't grant an injunction. So it follows almost like a mathematical equation. If I can't grant this as a final relief, I can't grant this today as an injunction. Therefore, all equitable considerations while granting injunction, which are ingrained in Order 39 of the Code of Civil Procedure, as I mentioned, the three tests of prima facie case, balance of convenience, inconvenience, irreparable injury, would matter little if 41 steps in. One more subsection let us go through before we read it in seriatim. That's HA. Section 41HA. Injunction cannot be granted if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project. This is relatable to 20 capital A, B and C, the infrastructure projects, which say that you cannot grant an injunction. Therefore, this is by way of clarification or abundant precaution. It's also brought in 41. 20 capital A says you can't grant an injunction, 41 clarifies it. It's clear that the injunction would definitely impede or delay the progress or completion of the infrastructure project, etc., as in 41HA. Now let's come to 41 once more and then go through it from A down the subsections. 41A, injunction cannot be granted to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought unless such restraint is necessary to prevent the multiplicity of proceedings. So I cannot file a subsequent suit and injunct the plaintiff of a prior suit from proceeding. The only ground is if it prevents a multiplicity of proceedings. Now I may draw parallels between this provision and section 10 of the Civil Procedure Code. Section 10 of the Civil Procedure Code, which deals with stay of suits. When the parties and the causes of action are the same, the plaintiff in the prior suit can ask for stay of the subsequent suit. Section 10 also says that it is possible for both suits to be taken up together and heard anonymously. Section 41A says that the subsequent plaintiff, the plaintiff in the subsequent suit, cannot injunct the plaintiff in the prior suit from proceeding with this judicial proceeding. This is really a follow-up, and this is a natural course of what Section 10 says. Now please come to B. To restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought. A lower court cannot grant injunction in respect of any proceedings in a higher court. In a hierarchically superior court, if there is a proceeding which is pending, the hierarchically lower court cannot injunct that. That is obvious because that would affect the committee of courts and the judicial chain of hierarchy. Then we come to C. To restrain any person from applying to any legislative body. Legislative bodies would be the Parliament, the Vidhan Sabha, etc. D we have already dealt with. We cannot restrain any person from instituting or prosecuting any proceeding in a criminal matter. We have dealt with 138 of the Negotiable Instrument Act. The same would apply to Section 420 or any other provisions of the Indian Penal Code or its Hindi equivalent. And one cannot restrain a person from prosecuting such proceedings. The only way such proceedings can be touched upon is by exercising powers under Section 482 by way of criminal revision or by Article 226 by way of writ jurisdiction. Otherwise, one would have to face trial in the criminal proceedings. One cannot file a civil proceedings and restrain criminal proceedings. There are cases, particularly in service jurisprudence, where we find that the employer has instituted both criminal proceedings and departmental proceedings against the same employer. There was also a lot of controversy and confusion as to which would prevail, which would supersede, which would abrogate the other. The law as it now appears is that both would proceed in its own way, because the basic principle is that the evidence probative value would be different. The evidence is different. In one, it would be that one would have to take the probability, and the other is that there is no other view except the view which the criminal court takes. E we have dealt with. F, to prevent on the ground of nuisance an act of which it is not reasonably clear that it would be a nuisance. Talking of tortious acts. G, to prevent a continuing breach in which the plaintiff has acquiesced. The acquiescence operates as an estoppel. If once there is acquiescence by the plaintiff, then injunction would not be granted. H, when equally efficacious relief can certainly be obtained by any other usual mode of proceeding except in case of breach of trust. Can any other equally efficacious relief be obtained? If it is possible to do so, then injunction will not be granted. H, A we have dealt with. I is when the conduct of the plaintiff or his agents have been such as to disentitle him to the assistance of the court. This is really the oft-quoted principle that person in equity must come with clean hands. So the conduct of the person is of prime importance. J is when the plaintiff has no personal interest in the matter. This is this is to, in furtherance of the principle that one cannot espouse somebody else's cause. In a private litigation, you have to espouse your own cause. If you have no personal interest, then you can't get an injunction. You have no locus standi to interfere and get an injunction. So this is section 41 of the Specific Relief Act, which deals with injunctions. Now I was on declaratory decrees and on declarations, and I came to injunctions because of the relation of declarations with section 41 of the Specific Relief Act. Now the issue which I had touched upon is with regard to civil death. Civil death is something that we deal with under the Indian Evidence Act. Section 107 and 108 of the Indian Evidence Act deals with civil deaths. Section 107 says that if a person is unheard of for more than 12 years, he is presumed dead. Section 108 carves out an exception and says that when a person has not been heard of for 7 years by those who would have naturally have heard of him, then had heard of him if he had been alive, then it is presumed that he is dead. Now, so far as this is concerned, these are rules of presumption, rules of evidence. Now, if a person has not been heard of for 7 years by persons who would have heard of him in the usual course had he been alive, then the presumption, statutory presumption, which is a rebuttable presumption, is that he is dead. Why I say rebuttable is because the person who claims that he is not dead, the onus would now be on him to prove that he is not dead. In other words, he is alive. Now, these cases arose primarily in cases when the person is no more there, not heard of, and his wife and children are claiming inheritance, either by way of benefits from his employers or from courts by way of the properties left behind. Now, let's say there is a case of a bank. The widow and the children apply to the bank and say that we are the rightful heirs. The missing person has not been heard of for more than 7 years. We are entitled to his retirement benefits, his pension, his gratuity, whatever are the statutory benefits. Now, the bank says, give me a certificate saying, or of a declaration from a civil court saying that he is not dead. Now, this question arose in a Calcutta matter. The suit was filed by the widow and the children of the missing person for a declaration. There had also been naturally a police missing complaint. The police gave a report saying that he was not traceable. The suit was dismissed on the ground saying that, see, section 34 requires a person to also deny that you have a right to a legal status or right to property. Here nobody is denying. The matter came to the High Court. The High Court said that one has to take a pragmatic view of the matter. One cannot read the section in this pedantic fashion. There are various ways to get out of this. One is that there is no bar in section 34 to giving a declaration. But even if section 34 of the Specific Relief Act did not apply, there is no difficulty because, as I said at the beginning of my talk, the Specific Relief Act is not all-encompassing. It is not a complete code. Section 9 of the Civil Procedure Code also enables the court to give declarations. So the High Court said that whether in terms of section 34 of the Specific Relief Act or in terms of section 9 of the Civil Procedure Code, derogates section 34, you can grant declaratory decree. Second, you are saying that there is no person who is denying. Now, if this person's decree is not, a decree that he is dead is not given, a declaration of his civil death, which is a legal presumption of actual death. It's not actual death, but a legal presumption of actual death being given by a notional decree of saying that there is a civil death. Is not given, then under the law of the land, the property would become escheat, because it would be a property in bona vacantia. It would become escheat and it would be taken over by the state. So in effect, the state would become ultimately the person who would be denying or interested to deny the person's right. Furthermore, you are asking for a legal status. Section 34 says anybody who has a legal character or right. What is a legal character? Legal character is nothing other than a legal status. And what is the legal status being sought? The person is asking for a declaration of civil death. But is that really what he is asking? The person is actually asking for a pronouncement of his death only so as to be able to get the property or the benefits or the privileges arising from that. So actually the declaration is that they are entitled to the property. And while passing the declaration, the court can always pronounce that because he is dead, therefore they are being entitled to the property. Therefore, they are also satisfying the requirement of having a legal character, because they have a legal status by way of being beneficiaries either under the Hindu law of succession or any other law of succession that may be applicable. So this is how the Calcutta High Court got around this issue. In a recent judgment in 2023, this is 2023 SCC Online Calcutta 290. And I find that other courts have also followed the same line. I find that similar judgment has been passed by the Allahabad High Court in 2024. The Allahabad judgment is 2024 SCC Online Allahabad 2310. 2024 SCC Online Allahabad 2310. There's an old Madras judgment of 1997. 97 is not old, but in the context it is older. 1997 1 LW 489. Now, so far as the Allahabad judgment is concerned, the 2024 Allahabad judgment, which I gave the citation of 2024 SCC Online Allahabad 2310. This is a division bench judgment and quite comprehensive. This deals with all aspects of the matter, all the points that I have mentioned. And it says that yes, decrees can be granted in terms of section 34 because there is no express bar. It satisfies the character of there being the requirement of there being a legal character. It satisfies the requirement of there being ultimately, if not today, ultimately somebody who would be denying or interested to deny. And the nature of the suit is really not a declaration of death, but a declaration of entitlement to the property of the deceased. And it also deals with the fact that apart from all this and dehoes the specific relief act, Section 9 of the Civil Procedure Code can also give such declaration in exercise of the inherent power of the Civil Procedure Code. So this is the issue with regard to the civil death insofar as declarations are concerned. There is one aspect which I had left out while we were dealing with the various topics, that is the right of a purchaser who acquires rights from a person who has no title or has an imperfect title. That is something which I had left out in the morning, and that is covered by section 13 of the Specific Relief Act. This is a very short topic. section 13 of the Specific Relief Act, which says that when a person contracts to sell, and it relates to immovable property, when a person contracts to sell or let out, but he himself has no title, or he himself has an imperfect title, then if he later acquires title, then he can be compelled to make good the contract. So he cannot escape the rigors of the contract on the ground that when he made the contract, he did not have title to the property. Now, so far as section 13 is concerned, it is to be read only with the caveat that this applies to cases where there is a misrepresentation or there is a fraudulent representation. The other thing is, if you have a look carefully to section 13, these are two things that I wanted to say. One is that it applies only in cases of misrepresentation or fraudulent representation or concealment. So if the purchaser, while purchasing it or taking it, knew that the vendor had no title or its title was imperfect, then he can't get relief. But if he is a bona fide purchaser having no knowledge, then this would apply. The second aspect of this section 13 is, if you see carefully, it applies to contracts to sell or let immovable property. It does not apply to charges. This is very important in the practical sphere because banks, when they give loans, ask for hypothecations or charges by way of collaterals. And very often we find that persons who are dubious purport to give charges or mortgages in respect of property over which they themselves have no right. The bank finds out too late that the person who created the charge or the security by way of charge or mortgage did not have title. Maybe it was the wife's property being given by the husband without the wife's consent, or it may be the father's property being given by the son, or the director's property being given by the company without the director having a personal guarantee. We find these fraudulent transactions going on everywhere. If what was given is only a charge, then the person who took this fraudulent charge will not get the benefit of section 13 and he will not be able to compel the person, even after the title has been perfected, to specifically perform the contract by making good the contract, the fraudulent contract. So this is an important aspect of section 13. Two aspects. One is that it does not apply when the person takes the property with knowledge. It applies only in cases of fraudulent misrepresentations or concealments. And secondly, it does not apply to charges or other encumbrances. It applies only in case of sale or lease. Because the contract itself says that when a person contracts to sell or let certain immovable property. So these are broad aspects of the Specific Relief Act which I had thought that I would discuss, and if there are any questions, I'd be happy to try and answer. Of course, every coin would have two sides, and I'm sure any answer that I give would be equally met by my other side if there was a litigation and say I am wrong and the other side is correct. But then law is a sea and we are just at the seashore. We are just trying to wade in and find our feet. Otherwise, this is all that I thought I would discuss with you on the Specific Relief Act.
Of his house being demolished, and even there is a danger to
Insofar as this is concerned, as the Supreme Court appears to say, hands-off policy, remedy is in damages. Remedy is in damages. Injunction cannot be granted because the expression used is an imperative clause. No discretion is left. Lawyers would say, Your Honor will find blood in Your Honor's hands. And that is a type of hyperbole that we lawyers use. But then when the law is clear, there is very little left for the judicial officer to do.
So, but what about courts which are looking after land acquisition cases? Can't they give any relief to the landowner?
Now, so far as Land Acquisition Act is concerned, it is before the statutory authorities. We are on civil courts trying civil suits. If you have a look at section 20 capital A, B and C, these are, let us go back to section 20 capital A. We are concerned with civil courts trying civil suits. No injunction shall be granted by a court in a suit under this act. So if the person aggrieved has gone to the first land acquisition collector and asked for relief, saying that declaration has not been made, notification has not been issued properly, declaration has not been made, compensation has not been payable. So the procedure under the Land Acquisition Act, now of course it's a new act, which is the Rehabilitation Act. So they would proceed. They would proceed. But in a civil suit, a civil court cannot grant an injunction. It is very clear, no injunction shall be granted by a court in a suit under this act.
So I had faced one case as a civil court. So there was actually a dispute to the title of the property that was acquired, and I think the highway, they were making a highway. So they asked for an injunction to stop the work and also to stop the compensation from being released to the defendant. So I stopped the compensation from being released, but I didn't stop the work. That's how I tried to solve the problem.
No, so far as the release of the compensation is concerned, so far as that injunction is concerned, that would be interfering with judicial proceedings in terms of 41A. Because there is a separate judicial proceedings which would be pending at the institution of the suit. But not granting injunction is the right course to do. Because you have no option, you have no discretion left in you. Because earlier on you would say justice, equity and good conscience. Now justice, equity and good conscience are given a go by. One has to follow the codification. And equity will follow the law. If law does not permit you, equity cannot step in. So really you have no option but to refuse, relegating parties to the appropriate forum. And as the Supreme Court said in the portion I read out, the remedy is in damages. Damages here is provided by the Land Acquisition Act itself because there is a provision for compensation. So if the compensation is not being granted, then it's a double whammy. On the one hand, he doesn't get the property back.
The compensation was already sanctioned. It was about to be deposited in the defendant's account, but the plaintiff is actually challenging the title.
So it's a matter of who would be entitled to the money. That is again to be decided under the statute. Who would be entitled to money is also to be decided under the relevant statute.
So during that time, I felt like holding the compensation will not affect the progress of the work, but we can't stop the work, and that's all I ordered.
Excellent. Maybe I could have got a brief in your court. Thank you so much. Thank you. Well, it's very interesting facets because we are reading trial statutes, but what happens in courts are human beings having human problems, and it is impossible to divest yourself emotionally from the emotions being felt by the litigants before you. When people come crying and they have no recourse except a court of law, how far can the judicial officer remain completely dispassionate and cut off from the reality of the situation? But then the problem is that there are higher courts And there's a hierarchy and a chain of courts which does not take kindly to the fact that the law has not been followed strictly by the book.